Hi and welcome back to another video on A-Level Law. Today we're going to be talking about consent, which is on the A-Level Law OCR specification on Paper 1, Criminal Law and the English Legal System. What do you need to know? Well, we're going to start by exploring what is consent, and then we're going to look at the differences between real consent, true consent and implied consent. We'll then move on to look at consent to minor injuries and the exceptions to these, and then finish with evaluation of the topic. So, some key facts you need to know about consent. Consent can only be a defence to battery and other offences against a person. It can never be a defence to murder or where serious injury is caused. So it's really important to remember that you can never use it for murder or where serious injury is caused unless there's some form of exception, which we'll look at shortly. Consent, strictly speaking, is not a defence, as if the person consents, there's no offence actually in the first place. So therefore, you don't need to defend yourself because there's no offence. But in the context of this, it is seen as a defence, but just bear that in mind. It is relevant to sexual offences, but we won't be discussing that here, although I will forewarn you, some of the cases we will be looking at do involve elements of a sexual nature and things like that, adult material really. So what is consent? Consent is a common law defence. It can be used for lots of cases and lots of offences, as I said, so mainly non-fatal offences and sexual offences. There's two main cases that really illustrate it, R.V. Donovan and R.V. Slingsby. In R.V. Donovan, he was engaged in some sexual activity with a young woman, and he caned her bottom with a cane and caused her sort of bruising and things like that. And it was whether he could use the defence of consent, because obviously she did consent to that, and it turned out that he could, and he was able to use the defence of consent. She consented to that battery or ABH, and therefore there was no offence, so therefore he could not be guilty of it. In Slingsby, he wore a signet ring and engaged in what the courts described as serious sexual activity or vigorous sexual activity. And he inserted his hand into her vagina, which caused serious internal bleeding, where the ring caused damage, essentially. She was too embarrassed to go to the hospital and subsequently died, unfortunately. And the court tried to charge him with unlawful act manslaughter. Now, if you know unlawful act manslaughter, that requires you to have done an unlawful act. He said, well, I haven't done an unlawful act because she consented to this activity. There was no battery or ABH or anything like that because she consented to it, and the court has found that she did, and there was consent. Therefore, he didn't do an unlawful act, so therefore he couldn't be guilty of unlawful act manslaughter. Now, when we look at consent, we need to look at several things. We need to look at real consent, true consent, implied consent, and consent to minor injuries. So if we start with real consent, there's four cases really that I've chosen here that pick out some of the key issues with real consent. We're going to start by looking at Tabassum in 2000. Tabassum pretended to be a doctor. He set up a sort of mini surgery in a car park and examined lots of women's breasts actually on the basis of collecting information for a database. So the people that consented to this thought they were doing it for that reason, but actually he wasn't a real doctor and he was doing it for sexual gratification. Now the court had to decide whether this was actually consent or not, whether he could use the defence of consent, and they said it wasn't real consent because they weren't consenting to what was actually being done or the reason why it was being done. It's a fairly complicated case, and we'll look at this in terms of the evaluation, because of course they did consent to actually physically what was being done, but not the reason behind it. But the court nonetheless decided that that was not real consent. In Oligbosia, you can also see them deciding that there was not real consent when a man basically raped a lady in front of another lady and then went on to rape the second lady who just sort of submitted and didn't really put up a fight or anything like that. And he tried to argue that was consent because she submitted to him and didn't do anything, didn't say no or anything like that. And they said that submission is not real consent. You know, mere submission is not real consent. Just because you didn't say no, that doesn't mean it's actually real consent. So therefore they said the consent wasn't real, and that's sort of a public policy case. You can see why they would say that in that case, because absolutely that's the right decision. In Richardson, she basically was struck off from being a dentist, and she continued to do dentistry work actually. And in this case they said actually there was real consent because she didn't actually, but she wasn't pretending to be someone else. She did exactly the treatment that the man asked for and the people asked for. Like, that she didn't do anything wrong with the treatment, anything like that. She did exactly what they asked for. So they said there was real consent. Although bear in mind that is a bit of a strange case because the reason, you know, they have consented if they knew she would have been struck off the list of being a dentist? Probably not. But nonetheless, she didn't lie about her identity and she did exactly what was being done. Whereas if you come back to Tabassum, he did lie about his identity. He wasn't a real doctor. Whereas she actually was a real dentist, she'd just been struck off the list. And finally, with Harvey Decker, he basically had sex with a number of ladies and he knew he was HIV positive and failed to tell them. And they said that the women were not able to give real consent because they didn't know. He needed to inform them that he did have HIV before they could actually make a real decision or not whether to have unprotected sex with him. So real consent is fairly complicated. You can see there's lots of different cases and avenues with it, but it's about really, being honest and upfront about things, and basically making sure that you're the real person. If you're a doctor, you're saying, if you're saying you're a doctor, you're actually a doctor. If someone's not submitting through fear, they are actually genuinely giving real consent, and actually you've informed them of everything they need to make a proper decision. Like if you look at Harvey Decker as well. If we look at true consent is usually really around legal capacity. So actually, can someone legally under the law decide or consent? So usually we're thinking of things around here like tattooing and things like that. And in Burrell v. Harmer, that's exactly that. Some young boys got some tattoos and the man who did the tattoos tried to say they consented. And of course, they couldn't consent because they didn't have the legal capacity, because you have to be 18 to be able to consent. And they say you have to be able to understand the nature of what happened for it to be consent. And they said, that's the point of it being 18 for tattoos, is anyone under the age of 18 can't understand the nature of that act of having a tattoo, really, in that regard. So whether you agree with that or disagree with that, that's the law with that. There is a fairly bit of complications on this because of a case called Gillick v West Norfolk and Wisbech Area Health Authority. V was legally capable of giving consent, and basically usually it's a child isn't, in terms of medical treatment and things like that, able to give consent. Usually it has to be the parent up until the child's 18. The issue in this case was that she wanted contraception. She was under the age of 18. And she wanted contraception. I think she was under the age of 16, actually. And obviously, normally, they'd have to ask the parent. But she was saying, well, I don't want you to ask my parent. I came without my parent because I'm embarrassed. I don't want my mum to know I'm having sexual activity. And they had to make this decision, because if they didn't give her contraception, the chances were she would go on to have sex and then possibly become pregnant, underage pregnancy. So they had to weigh up the balance of interest there. And they decided that in that cases, they could weigh up using something called the Gillick test to see whether that child is mentally capable of making that decision and consenting to that treatment. And if they could, then they could do that without the adults or the parents' consent. And that's called Gillick competence, or the Gillick exception, which you can see from the case of Gillick, which is a really useful case and really interesting case you talk about in your evaluation in terms of an exception to this true consent rule, really, where they can actually do it and sort of twist that test slightly, but obviously in the public's interest, because it's better perhaps to do that rather than have a teenage pregnancy in that issue. Implied consent, obviously sometimes the courts can imply consent. You might not have necessarily said, yes, I consent to that. So a classic example was in sports. If you get into a boxing ring, you put your gloves on and you get ready to fight and the whistle blows and you go for it. You might not have said, yes, I consent to possibly being hit, but, your actions imply it. And we know this is true because of a case called Wilson v. Pringle. And the court really clearly said in that the ordinary jostlings of everyday life were not a battery. So if you bump into someone in the corridor or on a train or on the tube in London, that's not a battery. That's you imply you consent implicitly to bumping into people and things like that. So therefore it's not. Same with medical situations. So if a doctor says you need an injection, or can they examine your arm, and you put your arm out and you don't say, yes, I consent to it, that's probably enough to be implied consent as well. So you can just bear that in mind and imply that in certain situations. Finally, we need to look at consent to minor injuries. Now, there's a main case on this called Agee's reference, and in this, two people agreed to fight in the street, and the court had to decide whether that was consent or not, and whether they could consent to doing that, and they said absolutely not. And the Court of Appeal actually heard this case, and they said absolutely not. They said consent to fighting would not be in the public interest, but they did lay out a number of exceptions where you can consent to sort of serious harm. And you can see a number there. So sport, medical procedures, horseplay, tattooing, piercing, branding, vigorous sexual activity, and there are others around stunts and a number of other things. So we're going to start by looking at sport. The Court of Appeal in Barnes held that if the injury is caused outside the rules of the game, they can be prosecuted. Otherwise, it is consented to and a lawful excuse. So if you lawfully tackle someone during a football game or a rugby game and you cause them serious injury, that's consented to because it's within the rules of the game. But if you actually went and punched somebody, which you can see in RV Billinghurst, for instance, that would be outside the rules of the game, and therefore you wouldn't consent to that. So if you went and bit someone on on a football pitch or something like that, that's obviously outside the rules of the game, so therefore could be prosecuted because you clearly wouldn't consent to that. So that generally applies to all contact sports. In terms of medical procedures, we saw this in Bravery v Bravery, where Lord Denning said it's really important around informed consent, telling a patient what you're going to do in advance and do they consent to that. You need to tell them all the information before they can consent, and then the risks and things like that. Some procedures are still illegal. So, for instance, euthanasia you can't consent to, same with female genital mutilation and abortion in some countries. And obviously bear in mind that mentally capable persons can refuse treatment. So anyone over the age of 18 can refuse any treatment, even if that results in death, as long as you've got sort of the mental capacity to do that. And if unconscious, medical professionals can act in your best interest. So they can do, usually to preserve life because of the sanctity of life. Horseplay, this is sort of messing around. The old-fashioned view is sort of tomfoolery, boys will be boys approach. It goes against the principle that people should not try to cause bodily harm for no good reason. And you can see this in two cases, R.V. Jones and R.V. Aiken. In R.V. Jones, the Court of Appeal held that a genuine mistaken belief to rough and undisciplined horseplay could be a defence. So in R.V. Jones, two boys threw some younger boys up into the air and broke one of them's arm, and the other one ruptured his spleen. Both had to go to hospital, etc. But they said, they consented to that because it was just messing around and horseplay and tomfoolery and things like that. So, that's quite an extreme case, but nonetheless, it shows that you can sort of mess around, and that'll be generally consented to. In R.V. Aiken, you can see that as well, where their convictions were quashed. The mistaken belief in the victim's consent should have been left up to the jury. So they may have actually been convicted if it had another jury, but not in this one. And that they were messing around with lighter fluid, setting fire to each other's RAF jackets. She went to sleep. They joked in and played a prank on her and set her on fire back, and it caused her 80% burns or third degree burns across 80% of her body or something like that. So really serious injury, but they said they consented. She consented to that, or at least that should have been left up to the jury to decide, which it wasn't in the trial case. Tattooing, piercing and branding. There obviously is a social need for this, although there are limitations. Burwell v Harmer, as we talked about earlier, you have to be a certain age, obviously. But can it go too far? There's a most recent case, R.V. McCarthy, 2019, where he split people's tongue, he removed an ear and a nipple, etc. And you can find the more information on that link there. And that's a really interesting case around whether you can actually go further than that in terms of body modification as well and things like that. Finally, vigorous sexual activity. Three main cases on here. Brown and others. This was the gay sadomasochism case, so a group of gay guys involved in some fairly serious sadomasochism activity, so that's causing injury or receiving injury for sexual gratification. There was no permanent injury or external medical attention needed, and they were all consenting adults, but the court convicted them and the House of Lords said that it was corrupting public morals. Now, this is largely considered to be an incorrect decision nowadays, especially when compared to Wilson. So in Wilson, he branded his wife's bum with a hot knife. It became infected. She had to have medical work done at hospital. And the court actually should have followed Brown because of the rules of precedent, because obviously Brown was a House of Lords case, so they should have followed that because this was a Court of Appeal case. But they actually distinguished the case because they said in Wilson they're a married couple and therefore it's a matrimonial home and it's different because it's very similar to tattooing and it's not as serious, so they weren't actually convicted. And there's a lot of criticism about the comparison between those two cases and some allegations of obviously homophobia and the fact that the gay guys were treated differently, even though actually more serious harm was caused in Wilson. Finally, there is clearly a limit, though. We saw in Emmett, he strangled his girlfriend until her eye popped out and poured lighter fluid over her breast and set it on fire, commonly known as the case of the burning boobs, which is a sort of funny reference for it, although not particularly funny, obviously. And she did fully consent, but serious harm was caused, and the court said you can't consent to deliberate infliction of serious harm. Like, absolutely not. Just simply not. So you need to kind of obviously compare cases to those as you go and see from that. Now I'm going to do another video on evaluation and scenarios, which I'll come back to shortly. So I hope you enjoyed that video, and check in for the evaluation and some reference on the scenarios next. Thank you very much.